Good morning. Let's go ahead and set forth our appearances. We'll start first with the plaintiff, then we'll move to the defense.
Good morning, Your Honor. Will Kemp, Plaintiffs.
Good morning, Your Honor. Teddy Park on behalf of Plaintiffs.
Good morning, Your Honor. Joe Odou on behalf of AffinityLifestyles.com Inc., Real Water Inc., and Real Water Gold Coast LLC.
Good morning, Your Honor. Robert Schumacher on behalf of Real Water, Tennessee.
Your Honor, on Blue Jeans, you've got Jim Neale on behalf of UNFW, along with Lou Brandon.
Blue Jeans as well. Oh, sorry. Scott Rasmussen on behalf of Hannah Instruments.
Lou Brandon on behalf of the defendant, United Natural Foods. Kevin on Real Water, Tennessee as well.
All right. Once again, good morning, everyone. And I think we have a couple matters on calendar.
Yes, Your Honor. We have a
Motion for leave.
yes, Your Honor. As far as I can tell, I've been opposed.
Yeah.
So,
And for the record, I'll make sure we get that clearly. Plaintiff's motion for leave to file second amended complaint on an order shortening time. And we have no opposition, is that correct? Yeah?
I've seen none, Your Honor.
Yeah, I haven't either. We'll go ahead and grant that.
Thank you, Your Honor.
Okay, we're going to move on. Next up, we have Real Water Gold Coast LLC's motion for a verdict as a matter of law pursuant to Rule 50A.
Thank you, Your Honor. Joe Odou on behalf of Real Water Gold Coast. As the court will recall, when this motion was first discussed in open court, UNFW took the position that the motion eliminating number 41 filed by plaintiffs somehow excused their attendance at court or at trial. We provided the court with not only a copy of the minute order, not only a copy of the actual motion, which is completely devoid of any reference whatsoever to Real Water Gold Coast, but also we provided a copy of the transcript. And the transcript from the hearing clearly and unequivocally has a statement of Jim Neale on behalf of UNFW acknowledging that that motion was moot. Therefore, for UNFW to now change position and say that somehow that motion preserved their claims is not supported by law or fact. Your Honor sat through the trial. Your Honor completely heard all of the testimony at trial. There was no mention ever during the course of the trial of Real Water Gold Coast. The simple reason is that Real Water Gold Coast is an entity that distributed water in California. As noted in our offer of proof, Brent Jones, had the issue been raised at trial, would have testified that Real Water Gold Coast only distributed water in California. He would have testified that the only reason why Gold Coast appears on computer printouts is because they didn't change over the computer system. Your Honor, this is a case where not only did the matter go to trial, not only did the jury return a verdict, but there was no opportunity for Real Water Gold Coast to contest that evidence because it never came in. UNFW attempts to attach documents that they claim they would have, should have, or could have put in at trial to somehow raise some type of tribal issue of material fact. None of those became trial exhibits. None of those were considered by the jury, and therefore, as a matter of law, Real Water Gold Coast is entitled to judgment. Moreover, Your Honor, during the course of this trial, it came up as to whatever UNFW was going to do with Real Water Gold Coast. The response was, well, we want to hang on to our third-party complaint. Well, you don't hang on to your third-party complaint by not appearing at trial, by not prosecuting. We now know, after trial, after the prejudice has been irreparably caused, that Real Water Gold Coast, apparently UNFW, has assigned some type of claim to the plaintiffs. We've never seen this assignment. We still don't know what the terms of the settlement are between UNFW and plaintiffs are, and they want to rely upon that to somehow maintain this claim. And finally, Your Honor, to just hammer home the prejudice here, the jury's been excused. This jury is gone. So what they're proposing is there will be some type of new trial between the assignee and Real Water Gold Coast with a different jury. That is absolutely 100% prejudicial. So not only is judgment as a matter of law warranted, it would be prejudicial to do anything otherwise.
Right, thank you, sir. And we'll hear from the opposition.
Thank you, Your Honor. Jim Neale on behalf of UNFW. Your Honor, if we go back to August 30th, the court will recall Mr. Kavanaugh and Mr. Schumacher arguing Real Water of Tennessee's third-party claim. And during that argument, the court essentially decided to dismiss UNFW's third-party claim against Real Water of Tennessee without prejudice. And that was dependent upon the bankruptcy's interpretation of its order. And the court invited UNFW to come back to court in a phase 3 of the trial if and when the bankruptcy court made an interpretation of that order that was consistent with UNFW's understanding of it and permitted the third-party claim against Real Water of Tennessee. During that discussion, Your Honor, everybody in the courtroom talked about a phase 3 of the trial. The phase 3 was going to occur after phase 1, the compensatory phase. After phase 2, the punitives phase, if that was necessary. And then we agreed, just like we do every day in construction defect cases, to take up the phase 3 issues, the cross claims and the third-party claims. And that included Real Water of Tennessee's claim, and that included Gold Coast's claim. We've submitted Exhibit A on our opposition. That's the transcript from August 30. Court very clearly says, come back for phase 3. I don't want you, Mr. Kavanaugh, sitting here in trial unnecessarily. Mr. Kemp said we ought to move all of the cross claims, third-party claim, into phase 3. And then, Your Honor, Mr. Odou said the same thing. And that's it. Exhibit A of the August 30 transcript. And if I can, Your Honor, I'll share my screen just to remind Mr. Odou of that. I'm sure he's just accidentally forgotten, but this is the discussion about Gold Coast. This is page 78 of the August 30th transcript, lines 7 through 17. Mr. Odou says there is still one remaining third-party complaint. It's against Real Water Gold Coast. I just want to alert the court to that there could be a need for phase 3, or however we do it. And the court said, yes, we'll do what we have to do. I'm not concerned about that. If there's indemnity claims or contribution claims. So all those things, we'll handle that just like we do day to day, routinely, construction defect cases. Your Honor, that was very clearly what the court instructed. That was very clearly what Real Water of Tennessee understood. They were excused from the trial. That's what UNFW understood. We were excused from the trial. That's what Mr. Kemp and we jointly proposed. And, Your Honor, that's exactly what we did. These are, of course, equitable claims. They're not legal claims. They're not for a jury to decide. They're for the court to decide. And even more pointedly, they have not yet accrued. They don't accrue until payment, as the court has repeatedly pointed out. And so they weren't ripe during the trial. And that's why everybody agreed that Mr. Kemp's motion in limine number 41 was moot, because we all agreed with the relief he sought. That was to keep all of the third-party claims out of the underlying case and to deal with them later if need be. Now that's exactly what the court instructed. That's exactly what the parties did. That's what we're prepared to do when we come back for the phase 3. And I'll just state briefly at that point, I don't think we need to get into the substantive evidence now, but we have a contract signed by Real Water of Gold Coast to Mr. Belsky. We have a statement of accounts from GC, Gold Coast, to Mr. Belsky. We have a route delivery sheet from Real Water Gold Coast to Mr. Belsky. And we have a payment. This is Exhibit F to our opposition, Your Honor. And I'll actually pull it up on the screen because I think it's the clearest evidence of all that judgment as a matter of law is inappropriate. This is Exhibit F to our opposition. It was Trial Exhibit 4287. It's a Real Water invoice to Mr. Belsky, instructing him to remit payment to Real Water Gold Coast. Real Water Gold Coast contracted to deliver the water. It delivered the water. It charged Mr. Belsky's account, and it billed him for it. Gold Coast put itself in the chain of distribution, Your Honor. Gold Coast is strictly liable for any defective product that causes injury. When we come back for phase 3, we'll introduce that evidence to support our indemnity and contribution claim. Those are the reasons the court can't enter judgment as a matter of law.
Yeah, Judge, I just wanted to correct one thing. We got an assignment of proceeds, not an assignment of the actual claim. So we, being the plaintiffs, share in the proceeds. And with regards to the contribution indemnity claim, Mr. Belsky hasn't even been paid yet. We have not received payment yet. We expect that by, I believe, December 4th is the anticipated date. So I don't see how the contribution indemnity claim even matures for UNFI at present. And I really think this is a phase 3 issue, that instead of a motion for 50 motion, that Mr. Odou should file a Rule 56 motion after the payment's made. And so we can advise him when the payment's made, but I don't see how you can say that they had to try their contribution claim before they even made payment. And whether or not there's an issue of fact, I think that's an issue for another day. But I would point out that there is some evidence that suggests that at least in 2018, they were getting the 5-gallon judge from California. And what I'm referring to is Mr. Pham's testimony. He was the quality assurance director from January 19 to May 19. And he pretty clearly says that there were deliveries coming from California, and that what happened down in California, they had an issue. But that's really evidence for another day. But I think what really we should do here is deny this motion. I can advise Mr. Odou the minute we get payment that he can tee up his motion for summary judgment. But I think procedurally that's what probably should be done.
Will do, sir.
Thank you, Your Honor. Again, seems like it's a slippery slope whenever we're arguing with UNFW, since they change position more frequently than some people change their ties. We see that there's a statement from Mr. Belsky that we don't know was ever given to Mr. Belsky. It was certainly produced by him, so perhaps it was. And it's in 2018, and it's for Real Water Las Vegas. That's the 2018 evidence, Your Honor. Had that evidence been provided to the jury could have considered it. The evidence that Mr. Neale now wants to proffer is from 2020. This court's well aware Mr. Belsky was injured in 2018. The jury returned a verdict for his damages for his medical costs in 2018. To now change position and say, oh, well, maybe Mr. Belsky got water in 2020, which he didn't, is just another attempt by UNFW to avoid judgment as a matter of law. As this court is very well aware, in a construction defect case, we have a trial protocol. In that trial protocol, the case is broken up into phases. In that trial protocol, typically the same jury that considers the first phase of the trial considers the second phase or the third phase of trial. It is absolutely 100% prejudicial to now have a new jury consider these factual issues. Plaintiff invites us to file some type of motion for summary judgment, knowing full well that the next position that they'll take is there's a material issue of fact that needs to be determined by a jury. That jury has been excused. That prejudice is way past. It cannot be cured by this court. There was no order preserving this. Mr. Neale said he wanted to hang on to it, but he didn't hang on to it. He cites the record from August 30th. We cite the record from August 31st, where Mr. Neale's own words were, the court says I don't have the ruling on plaintiff's motion eliminating number 41. Mr. Kemp says 41. Mr. Peppermint says it's moot. Mr. Kemp says I have that as moot. Mr. Odou says yeah. Mr. Rasmussen says, so does that mean withdrawn? Mr. Odou says, that was Real Water Tennessee. Mr. Kemp says, yeah, that was Real Water Tennessee, which became moot when they got their summary judgment. Mr. Neale says, moot, so it's okay. That's Mr. Neale the day after the portion of the transcript that he wishes to cite. Again, notice and opportunity to be heard. There was no trial protocol in this case. The claim was not preserved. The jury has been excused. It's absolutely 100% prejudicial now to not grant this motion.
Okay, thank you.
Your Honor, may I briefly?
Oh, absolutely.
Okay, Robert Schumacher for Tennessee. Just want to make a record that our client disputes Mr. Neale's characterization of the court's ruling on Tennessee's motions for summary judgment as to Belsky and Haley. The record is what it is, and we're currently in the meet and confer process with Mr. Neale, trying to get an order that we can submit to the board. Thank you.
All right, and thank you, sir. And I just have a couple comments before I rule. And I feel it's very important for the parties to be able to rely upon pronouncements made by the trial court during the course of litigation. I mean, it really is. And we did have a discussion as to how to handle the potential contractual indemnity. I don't know if there's an equitable indemnity claim or not, and or contribution. And it's important to point out that this case, there's no question I said what I said regarding phase 3. The record speaks for itself. But just as important, too, this case is a little unique in that the primary thrust, focus, and scope of the jury in this case was to make one determination as it pertains to liability. And that's whether or not there was a defective product unreasonably dangerous pursuant to Restatement of Torts 402A. And the jury made that determination. And subject to appeal, that decision stands. Secondly, the only issue remaining focuses on whether or not there was a distributor relationship here. And that's it, because we don't need to rehash the jury's decision as it pertains to 402A, and they made that decision. You know, they made a determination the product was defective. And so I'm going to deny the motion. I'm going to live by. I realize we didn't have a trial protocol, but informally we did, because I did make a pronouncement that we're going to handle that in phase 3 of the litigation. And as far as phase 3 is concerned, I would anticipate ultimately that should be a fairly simple determination. But at this point, I'm going to deny the motion, because I do think it's very, very important for counsel to be able to rely upon statements made by trial court, right? Because if you couldn't rely on a statement by the judge, that'd be problematic. It's probably the best way to say it, right?
Yes, sure.
Yeah, it would be a problem. So I'm denying the motion, and we can deal with these issues, I guess, as they come up post-trial. And I know you're gearing up for another one, right?
Yes, Your Honor. And Judge, just as a matter of housekeeping, we have prepared the judgment. We emailed copies to opposing counsel if they have comments. So we anticipate entering to the court sometime this week, either tomorrow, maybe even later today, depending on their comments.
Yeah, and as far as that's concerned, I mean, I'll be around all week, so.
Okay, thank you.
And we try to have, for the most part, a pretty quick turnaround on all orders. You know, typically 24 hours. Correct? All right. Anything else?
That is it.
So you're gearing up, huh? Okay. When's our next trial in this matter?
Oh,
January next year?
no, it was June. Was it June?
Is it June?
We had, you know, we just met with Special Master Hale at this exact point.
We did.
Well, I think what happened, we did a follow-up, and some of the cases didn't have trial dates. And so, you know how I am. I want to make sure that we have trial dates for every case.
Exactly.
We have 3 coming to you, Your Honor, for trial in September. Yeah.
Yeah.
For August?
Yeah.
But we try to stay on it, you know, and I have to compliment my staff. That was Len that looked at the scheduling orders and the like, says, we don't have a trial date. We got to have a trial date.
Thank you. Your Honor.
Thank you, Your Honor.
Enjoy your day.
Thank you, Your Honor. Appreciate it.
All right.